And ladies and gentlemen, kia good evening, and konbanwa. You know what konbanwa means, good evening in Japanese. It's my great pleasure to welcome you all this evening to the discussion of the rule of law at sea and the future prospects of island states. I would like to thank NZIA, the New Zealand Institute of International Affairs, for collaborating with our embassy on this event, and Victoria University of Wellington for providing this wonderful venue. The discussion this evening will examine maritime issues in Pacific. Island states face challenges from changes in the marine environment, such as rising sea levels, and also have the potential to benefit from the exploitation of marine mineral resources. In this context, for the purpose of maximizing the profits and solving their problems, island states are expected to respect the rule of law at sea. I am very pleased to introduce to you our special guest from Japan, who will lead the discussion on the aforementioned topic. Dr. Seta Makoto. Let me say a few words about our names. We put our family name first, which is Seta, and Makoto is his first name. But we used to use the other way around abroad. He used to be Makoto Seta, but allow me to say this time Seta Makoto. For instance, I'm Kobayashi Hiroyasu, family name and first name, just for your information. He's an associate professor at Yokohama City University and adjunct researcher with the Institute of Maritime Law at Waseda University in Tokyo. Dr. Seta's research interests are in the international law of the sea and the international criminal law, as well as giving presentation on issues about maritime law around the world. He has published widely on the topic, including a solo work on the international law for ocean governance, and collaborated on a report on the obligations of the states under the United Nations Convention for the Law of the Sea in respect of undelimited maritime area. With his extensive knowledge, I'm sure you will find what Dr. Seta, a very promising scholar in the area of maritime law, has to say very interesting and informative. Holding this seminar this time is quite timely, because last October, Foreign Minister Winston Peters and his Japanese counterpart, Mr. Motegi, our Foreign Minister Motegi Toshimitsu, held a meeting in Tokyo, which resulted in issuing a joint declaration on cooperation in the Pacific Island region. The two countries have been working on formulating concrete projects in this region. In closing, I would like to thank Dr. Bevan Marten, Senior Lecturer in Law at Victoria University of Wellington, who will be taking up the role of facilitator tonight. Dr. Marten, specializing in maritime law with strengths in commercial, regulatory, and international law aspects of the field. And he's a scholar of, he's the author of Maritime Law in New Zealand. I hope everybody will enjoy the discussion tonight. Thank you very much.
Thank you, Ambassador Kobayashi, for your kind introduction. Kia ora. My name is Makoto Seta. So I'm from Japan, and I'm teaching public international law at Yokohama City University. And does anybody know where the Yokohama is? Does anybody know what's the city of Yokohama? The city of Yokohama? Okay, some of you know it. And actually, technically speaking, Yokohama is the largest city in Japan. It's not Tokyo, because Tokyo is a prefecture in the administrative unit. And my university is established by Yokohama City, and he or she is a mascot for my university. And yesterday I had a dinner with Dr. Marten, and he said that he likes kind of Japanese animation, so probably some New Zealander might have the image for Japan like this kind of mascot, and my university has it. And also Yokohama might be familiar for you because of the last year World Cup. Actually, the opening game for All Blacks was also held in Yokohama City, and unfortunately, I have to confess that the end of the All Blacks, so the semi-final against England, was also held in Yokohama. Anyway, so this is today's content. So after a brief introduction, I will elaborate the exploration of marine mineral resources and sea level rise issues, respectively, and we'll make some conclusion. So first of all, so I want to highlight the kind of a similarity between Japan and New Zealand. So both of them, so they are island states, we can say. So, and actually before coming to New Zealand, and it's the first time for me to come to New Zealand, and I just saw that New Zealand has two islands, but I learned that so it has more than 600 islands, right? And does anybody know how many islands does Japan have? Actually, so probably some of you might think that there are 4 islands. So there are very big 4 islands: Hokkaido, Honshu, Shikoku, and Kyushu. They are 4 huge islands, but including small islands, more than 6,000, so 10 times. So it has many islands, and so that's why both two states have huge maritime area. But before that, I want to confirm the basic rules of the international law of the sea, which are provided in the UNCLOS, UN Convention on the Law of the Sea. So first of all, states have to decide the baseline, and on the basis of that baseline, so states can extend 12 nautical mile, up to 12 nautical mile for territorial sea. And over territorial sea, states have sovereignty, territorial sovereignty. And up to 200 nautical miles, states can establish exclusive economic zone. And also up to 350 nautical mile. It's based on the condition, or geographical condition, but sometimes can extend continental shelf to up to 350 nautical mile. But and beyond that, as for the sea floor, ocean floor, it's called so-called the area, and the ISA, International Seabed Authority, has strong power over that area and over the water column. So it's open to all states at the high seas. And before talking on some rules of the law of the sea, I want to confirm the basic principle. So that is that the coastal states do not have sovereignty over continental shelf, neither continental shelf nor exclusive economic zone. What coastal states have is just sovereign rights, right? So sovereign rights is different from sovereignty. So we have to note this fact. But anyway, so New Zealand have very huge exclusive economic zone, and also Japan. So, and this is the number of the two states. Yes, so as for area of land, Japan has larger land, but if we include all maritime jurisdiction, maritime area, especially New Zealand has a very huge area of extended continental shelf. So in total area of maritime jurisdiction, so New Zealand has a larger area compared to Japan. But in any case, both Japan and New Zealand has a very huge maritime area compared to its land area. So I think this is one of the same feature for all island states. I think almost all the island states have the similarity. They have the huge maritime area compared to land area. Okay, so next I want to explain the current situation of exploitation of marine mineral resources. And as for when I say marine mineral resources, and especially in this presentation, so it does not include oil and gas. So basically, those mineral resources are regarded as consisting of the three types of mineral deposit. So first, polymetallic manganese nodules. So it's like this. And seafloor, and it includes manganese, nickel, copper, and cobalt, so some so-called rare metal. And second, seafloor massive sulfides. So like this, like that. And it includes a copper, gold, silver, and zinc. And the last one is a cobalt-rich crust. So unlike oil and gas, so when the states exploit oil and gas, so usually they just drilling and vacuum from the deposit in the seafloor. But in the case of those types of marine mineral resources, corporation or states, whatever, so the subject which try to exploit these resources have to dig rather than drilling to the seafloor. So it is said that so probably the impact against maritime environment would be larger than the developing oil and gas. Okay. And as for the as for the area, so area beyond national jurisdiction over the seafloor, in the seafloor, this International Seabed Authority has a strong authority, and actually this ISA divided the deposit in these three ways. So that's why I just follow the distinction. Okay, and also, recently, it is widely said that probably the development or utilization of such marine mineral resources would be a huge benefit for Pacific Island states. And it's also appointed by the World Bank. Its report published in 2017, it says, so driven by the relatively high grade of deep sea minerals, DSM, including rare earth elements and technological advance, deep sea mining is emerging as a new industry in the Pacific, it said. And it's also said by the New Zealand, but at the same time, the government of New Zealand showed a kind of a concern. So in its kind of a report published by the Ocean Research Project, which is conducted under the Ministry of Foreign Affairs and Trade New Zealand aid program, so it says that although this industry means the industry for the deep sea mining, this industry may provide economic benefits, it may have an adverse effect on other industries, such as fishing and tourism, especially ecotourism, through the destruction of marine ecosystems, which may in turn reduce living standards for Pacific Islanders. So, it is said that the development of marine mineral resources would be a kind of a good economic chance, but at the same time, it would give a negative impact on the marine environment. So probably it's really important for us to consider and take the balance between development and the protection of the marine environment. However, unfortunately, ecosystem of the ocean, especially the deep sea, especially the ecosystem in the deep sea, is still unknown. So nobody knows the kind of detail of the ecosystem in the deep sea area. So how should we decide? How should we take the balance? So because of the lack of the scientific evidence and information. So I want to show some example. So actually, this is the kind of ongoing project in Japan. So this hole is Izena Hole, and this island, the closed island, is Izena Island. So the distance between Izena Island and the Izena Hole is almost 100 kilometers. And actually, Izena Island has this kind of a very beautiful landscape. It's very beautiful sea, right? So how do you feel? What if Japanese government decided to develop the mineral resources 100 kilometer distance from this island? It sounds very difficult for us to decide, right? So we cannot imagine what kind of damage would be given from the 100 kilometer distance. So I think it's very important for us to establish procedure for decision making. And as for this decision making, so probably it's highly recommended that all stakeholders should be involved with the decision making. So like the people living close to the area. So and in this context, probably it's difficult for us to define what is the people. So local people, for example. So local people participation might be important, but it's a little bit difficult for us to define who would be the local people. So is it local, even if they live in the 100 kilometer distance? So, but anyway, in any case, so local people and industry, so the corporation which try to develop those resources, and also the NGO which try to protect the environment. So probably the participation of those stakeholders is essential. And in order to establish such procedure, I believe that the legal framework is very important. So legal framework should provide the rules for such procedure. And on this point, actually, New Zealand have already enacted its own municipal or domestic law in 2012. So it's named EEZ and Continental Shelf Law. And it firstly classified the activities into the 4 categories. So permitted activity and non-notified discretionary activity and prohibited activity. And in the middle, 2. So if a corporation, an entity get a permission, so that a corporation entity can develop can use the marine area for that purpose. And this permission system is named a kind of a system of marine consent, and it is the Environmental Protection Authority, EPA, which has the discretion to decide whether that consent is given or not. So in this framework, so New Zealand government decided to give the strong discretion to the Environmental Authority. And as for the Pacific states, thanks to the support by the EU, especially European Development Fund 10, so they established a kind of a regional framework, so named Regional Legislative and Regulatory Framework for Deep Sea Minerals Exploration and Exploitation. And this can be a kind of a model for the domestic legislation in Pacific states. So recently, many Pacific states have established their own domestic legislation for deep sea mining. So Tonga in 2014, and Tuvalu, Kiribati, and the federal states of Micronesia, and Cook Island also devised its legislation for deep sea mining. And I can also point out the fact that so in each state legislation, the balance between the development and protection of marine environment, in other words, the involvement of both mining and environmental authority is provided. So actually this point is notified by my co-researcher, Professor Kake, who works for the Hiroshima University. And lastly, I want to introduce the Japanese leading project. And unfortunately, Japan has not established any legislation for deep sea mining in its domestic legislation. But actually, so Japanese project research team leads some project, and that is the establishment of the ISO standard, which can be applied to the deep sea mining. So in 2016, ISO, International Organization for Standardization, established Working Group 4 of the Subcommittee 13 and Technical Committee 8 for the purpose of making ISO standards on marine environment impact assessment applicable to all maritime areas, including seabed. and that working group is expected to provide the technical standards for use in MEIA, especially for deep sea mining. And this standard is just a private standard, so it does not have any kind of a public background. But if the stakeholders widely accept this standard, so probably that standard would be used and applied in many situations. So in that sense, this kind of development of this kind of standard would also facilitate the good governance for the ocean. And in that project, in that research team, so in that working group, many Japanese researchers participate in it, and also some researchers consider that the edokko, so this is the this item is named edokko and developed by the Japanese small company, and such technology can be very useful for marine environment impact assessment, especially for in the context of monitoring. Okay, so next I want to move to the sea level rise issue. And this is the map of Yokohama City. So my university is located here. This is my university, and actually I'm living here. Anyway, so this map stands for the 0 meter sea level. So 0 meter sea level means that so this line, blue line, is under the sea level. So actually the sea level on this part is under sea level, but thanks to those lines, so it does not covered by the water. And it is pointed out that in the worst scenario, so by the end of 21st century, the 2 meters, so sea level would rise in the 2 meter. And if the sea level rise 2 meters, the map would be like this. And if the ice over the Greenland, whole ice over the Greenland is melted, it said that the sea level rise for 7 meters. And if 7 meter sea level rise realize, the map would be like this. So in this way, so probably I think almost all island states are very vulnerable to the sea level rise problems. So in this scenario, so my university is covered by the ocean, and my home is already sunk. So of course I want to avoid such situation. So yeah, many, both Japanese government and New Zealand government demonstrated their concern for the sea level rise issue. And especially in the case of the Pacific Island, especially Tsubao, so it is said that so the sea level rise would give a huge negative impact on the livelihood of the people in the Pacific Island. And as for the international law on that problems, International Law Association, so probably one of the most prominent academic society in the field of international law, extensively has engaged to studying these problems. And ILA, so ILA make a kind of point out raise a two perspective. One is short-term perspective, and the other one is long-term. So, and short-term perspective can also be divided into the two categories. One is the law of the sea issues, and the other one is forced migration and human rights. But actually, as I said, I'm a specialist on the law of the sea. I would focus on this law of the sea issues. So actually the ILA established the committee to study this sea level rise issue, and also the committee adopted its final report in 2018. And the committee said that its position is that it seeks to minimize the impact of sea level rise for the settled law of the sea. And as I demonstrate in the previous slide, so actually the maritime area is based on the baseline, and the baseline is drawn along with the land territory, right? So if the sea level rise and the maritime feature, so land, the baseline is changed, so that means so maritime area must be changed if we comply with the principle. But if we do so, so that would make the maritime delimitation or maritime area very unstable. And in the case of New Zealand, so New Zealand has successfully concluded the bilateral treaty for maritime delimitation with Australia, right? But if the baseline would be changed, so that might give an impact on the maritime delimitation. But the ILA committee considers that such situation should be avoided. The impact should be mitigated. So for that purpose, the committee published the report, and committee considered that there are two approaches to maintain the current situation. And one is the maintaining baselines despite physical change brought about by sea level rise. And the other one, second one, is maintaining existing outer limits despite physical change brought about sea level rise. So there are two approaches, but actually, so that is just a report published by the ILA committee. So if the island states want to introduce that kind of idea into positive international law, so there might be three ways. So one is the way to interpret treaty. So we can change the treaty interpretation, and even the current provision of the UNCLOS accept the kind of maintenance of the baseline or maintenance of the outer limit of maritime area. So that is one way. The second one is establishing a new treaty. If states concluded a new treaty which maintains the baseline or outer limit of the maritime area, so also a treaty binds the states legally, so new law can be established, and also we can also expect the emergence of new rules of customary international law. And as for these three methods, so as for treaty interpretation, according to Article 31 of the Vienna Convention, subsequent practices of state party is important. Of course, when we establish new treaty, the participation of the state is very important, and in order to establish new rules of customary international law, the state's practice with opinion leaders is essential. So in any case, the consent of states is very important. So, okay, I will make some very short conclusion. So, as for the exploitation of marine mineral resources, coastal states shall exercise their sovereign rights in accordance with international law. Because, as I said, sovereign rights is different from sovereignty. And actually, some provision of the UNCLOS require the coastal states to comply with the rules to protect marine environment, which are provided in Part 12 of the UNCLOS, for example. So, even if they exploit the mineral resources in its coastal, in its EEZ or continental shelf, they have to respect international law. And for that purpose, municipal domestic legislation for exploration and exploitation of marine mineral resources must be in conformity with the international law. So, and actually now we do not have the kind of detailed rules for the exploitation of marine mineral resources. So probably it's essential for us to achieve the international cooperation to establish such rule. And as for the sea level rise issue, in order to minimize the impact of sea level rise for the settled law of the sea, as I said, irrespective of whether we establish new law, new treaty, or change the interpretation, or expect the emergence of new rules of customary international law, the state consent is important. So for that purpose, the international cooperation is essential. So I want to highlight that the solidarity among the island states would be the key to protect the interest of island states in accordance with the law of the sea. And so this is the end of my presentation. Thank you for your listening. And so I'm sorry, I forget to tell it, but I also would like to extend my sincere gratitude to the NZ and also the Embassy of Japan to give me the opportunity to make this presentation. And also thank you for joining the conference. Thank you.
Okay, that's on, I think. I can talk loudly. So it's my pleasure to introduce some questions into the mix and tease out some of the ideas that Dr. Seta has been discussing. He's had a few, I've given a few tips in advance, so this is going to be less in the kind of Kim Hill interview zone and more in the Brian Crump at Night's interview zone, which is a reference for our radio listeners here. I'm especially pleased to be doing this, I think, in the last week or so, or few weeks now, we've been feeling a lot more international. We've been paying a lot more attention to international news, international flight plans. Events like this are quite precious because more and more seem to be getting cancelled.
Yeah.
And I was thrilled when I saw that your flight was departing very safely the other day. So we in New Zealand have a very particular view of our place in the world in terms of the Pacific Islands and how we can be a sort of big brother, big sister nation to these small states. What does Japan see its role as? What is the perspective from Japan in terms of the Pacific Islands? Because I want to talk more about those small countries in this period.
Okay, yes, thank you for your question. And I think so Japan has a kind of a very complex feeling against Pacific Island, and one of the reasons is the kind of a history of the World War II. And also, but at the same time, Japan notes that the Pacific Island, first of all, geographically, it's very close. And as I mentioned, it has a similar character as an island state. So recently, Japan also started to hold the kind of a so-called island summit, so to invite the leader of the island states and to discuss the kind of common challenges and the future cooperation. So in that sense, Japan considers that it also would like to enhance the cooperation with island states. And in this context, I think that Japan expects New Zealand as a kind of a partner to lead the discussion. So, and personally, it's actually I'm just a researcher, so I cannot, of course, say the view of the Japanese government. But personally, when I study the kind of especially domestic legislation in the Pacific Islands, it's quite difficult for me to understand. It's different from kind of our culture and our system. So, but of course, I understand more. Of course, I'm not familiar with the New Zealand domestic law very much, but still compared to the system in the Pacific Islands, so the system in New Zealand is much easier for us to understand because some of Japanese people studied in UK, and also the New Zealand system is inherited from the UK.
Oh, and you yourself studied in your PhD at London School of Economics.
Master, yeah. So in that sense, and so if the kind of New Zealand work as a leader, so especially Japan share the kind of a value like human rights protection, democracy, and the rule of law with New Zealand, and so in that sense, I think the leadership by New Zealand is very helpful for Japan as well.
And so with the, you looked at some, and I want to talk a bit more about the domestic legislation shortly, but when we look at the international law around minerals, so I'm on the seabed mining here, what role do we already have? What is already dealt with in UNCLOS? How much do we already have, and how much are we going to have to create if we want a role for international law in this area?
Okay, yes, so within the framework of the UNCLOS, so probably it's better for us to make a distinction between the area beyond national jurisdiction and the area within the national jurisdiction. And as for the area beyond national jurisdiction, as I said in my presentation, the ISA has a strong power over it. And ISA has already developed some rules for the exploration, and now is developing the rules for exploitation as well. So in that sense, ISA rules would be a kind of a good reference. But technically speaking, as I said, so ISA is in charge of the area beyond national jurisdiction. So it is not directly applied to the continental shelf, neither exclusive economic zone. But as I said, even coastal states exercise their sovereign rights, so their kind of exercise must be complied with international law. So in this context, what international law provides is not clear, at least it's not detailed, provided in detail in the UNCLOS. So we have to consider it. So if the one state exploit the mineral resources in the continental shelf, and if it give a kind of a huge negative impact on the marine environment, it would constitute a violation of the UNCLOS, I think.
And so when you were looking for a domestic regime, and we have one which you pointed out, which I think we've amended every year since we enacted the 2012 Act, what sort of work do you think is already ongoing in Japan or might emerge in Japan soon? Are you going to going to be involved in some drafting, some project team?
Actually, I have some information on that issues, but as far as I know, still Japanese government has not decided the kind of amendment or establishment of the new legislation on that point. So as far as I know, there are many kind of ways to establish such rules. For example, Japan has its own municipal mining code, which is applicable to the land area. So probably one of the ways is to amend that mining law, which can be applicable to the maritime area. And also some politician or even politician claimed that the exclusive economic zone act like New Zealand should be established. So there are, I think, several ways to have such domestic legislations. But as far as I know, Japan has not decided its position yet.
And with the reference you had in your talk to the ISO standard,
Yep.
is that something that appears in Japanese law a lot, or is that a rare thing to find as a sort of way of setting standards? It's not something not something lawyers in New Zealand tend to look at too much unless they're in a very specific industry.
Yeah, actually, the ISO standards often appear in the kind of a shipping legislation in Japan. So in the maritime industry, ISO standards are very widely used, and also even Japanese municipal law manifestly mentions some ISO standards. So in that sense, ISO standards are respected. But as I said, it's in the context of shipping or other maritime area industries. So I cannot say that now that ISO standard would be widely used in the industry of deep sea mining or other field, but we can expect it.
So would you have known what one was when you left law school, or would you have known what an ISO standard was when you left law school? I would not have.
Yeah, actually, so basically the law students don't study ISO standard.
And so when you looked at the Pacific Islands domestic legislation, obviously, New Zealand has one model, but you mentioned, I think there are about 4 or 5 up there. Do you know anything yet about the origins of those acts? Were they developed internally within the island state, or do you think they were sort of presented as a fait accompli by a foreign mining company or someone who said this is the law you should enact?
And actually, it is strongly supported and pushed by the European states. And as I show in my slide, so European Development Fund EDF 10 set the kind of a project for the deep sea mining, and under the scheme of that project, so it shows the kind of a example of the model domestic law or the points which should be considered when they establish domestic legislation. And actually, some states' national legislation is kind of not just a copying, but strongly affected by that model law, so regional framework.
Right. And so what do you think, whether it's a role for international law or New Zealand and Japan as regional actors, what can be done to help these small island states if foreign corporations are going to go in and exploit the resources? Because I don't think they'll have the capacity in their own countries. How can we best protect them? Is there anything that, as I say, we can do as actors or law can do internationally or otherwise?
Yeah, so probably as you pointed out, I also agree with that the local people cannot develop the marine mineral resources by themselves. So probably foreign corporation and investor come and develop those resources. So the natural resources in that region would be kind of exploited by those corporations. So in order to avoid such situation, so what the Japan and New Zealand or other regional states can do is, so firstly, just giving an advice, and also the kind of strengthen the kind of solidarity among the nation is quite important, because if one state gave some kind of a bargain sale, for example, so that sale would be a kind of a future standard, and such scenario might be the worst for the Pacific states. So in order to avoid such situation, so I think the providing information and also the establishing the good framework and also the solidarity, strengthen the solidarity, so that is the important factor, I think.
So I think it's an interesting piece of context that in New Zealand, having had the Act in place for some years now, we've had two applications for deep sea mining, one for iron sands in 2014 and one in 2015 for phosphate, and both have been declined by our EPA.
Yeah.
So the interests in the environmental protection aspects and the economic benefits have not weighed up as far as our agency is concerned. So the equivalent in a small island state may be under some pressure to resist this desire for economic growth,
Yes.
despite these risks which which arise when you're dealing with anything that far offshore. So I want to also ask, if you had a whole pile of money to offer as a sort of aid grant, if you got to design your own project, what would, in this area, what would you most want to have researched or developed if you could control the purse strings, control the wallet for a project?
Yeah, I just try to provide some equipment which can be useful for the marine environmental impact assessment. So because I think EIA is a very key for the developing of the mineral resources in the seafloor, but actually it takes a huge amount of cost. So probably it's very nice for Pacific states to have such kind of equipment which can be used for the marine environment impact assessment.
Very good. I hope the funding agencies are listening.
Yeah.
We will. I just now want to talk about sea level rise for a bit, and we had identified recently just 2 years ago. We've both seen the speech by New Zealand's head lawyer Victoria at Foreign Affairs. So it's something that has been in the minds of New Zealanders for some time, and obviously, like Japan, we share this geography, which is both island in nature, affected by volcanoes, earthquakes. We are both in unstable islands. We share that. So when we look at the definition of island and the meaning of island, and I know this has been fleshed out to some degree by an arbitral decision, what is an island in natural law? I think this, for the non-lawyers, this is quite a question for definitions.
Yes. So it's very difficult, and but basically I can say that the kind of a scheme of the island is provided in Article 121 of the UNCLOS, and as you mentioned, so the arbitral tribunal in the South China Sea arbitration interpreted that provision, and it said that the maintenance of the human life and also economic life. Economic life is a very important factors for as a condition to for maritime feature to be regarded as an island. But I'm not sure to what extent this interpretation by the arbitral tribunal is widely accepted, because after that, in the case between Nicaragua and Colombia, the ICJ had the kind of occasion to interpret the same provision, but in that case, both parties did not mention to the arbitral tribunal. So in that sense, ICJ was not compelled to say so, but ICJ could rely on the arbitral award, but it didn't refer to the arbitral award at all. So still it's ambiguous, but according to the arbitral tribunal, we can say that the maintenance of the human life is a very important factor. Yeah.
Which, of course, in relation to a lot of New Zealand's southernmost islands, would be a very cold life surrounded by seabirds and very little else. So it is a discussion that we will no doubt return to. And I think there's probably some piece of questions in the audience about that too. But is this, naively, is this going to be an easier question? Because if the sea level rises and the baseline shrink or the landmass goes smaller, boundaries could only shrink. So no one's looking to expand. Does that make this an easier problem to solve? Are we going to be able to deal with this more easily than if we were trying to say expand boundaries rather than protect existing ones or accept shrinking?
I think so. Yeah, I agree with it. Actually, the committee of the ILA pointed out that some states claim that the kind of fundamental basic rule should be applied, so which means that the maintenance of the current maritime area is not acceptable in accordance with UNCLOS. It's because if we literally interpret UNCLOS, the sea level rise is not supposed at all. So there might be a kind of an a claim which said that the maintenance of the maritime outer limit or the baseline is not accepted, but just I also point out just kind of a possibility, but as far as I know, so far no states have claimed officially that kind of thing. So probably for the inland states, for example, it's better for inland states that maritime area of each coastal state is shrinking. So because that means that the area and also the high seas will be expanded. But as far as I know, no even inland states haven't claimed so. So probably they are also sympathetic for the especially smaller Pacific Island state, and the current maritime order should be maintained.
Right. And when you mentioned the possibility of a new rule of customary international law, what might that look like? What's an example that you've thought of in that?
Actually, ILA also said that's the kind of a possibility for the emergence of new rules of customary international law. And so new rules of customary international law say that, for example, the baseline which was fixed after the UNCLOS and should be maintained irrespective of the impact of sea level rise or so. Such kind of rules of customary international law would emerge, but so if all states consider that, so they are customary international law. But from the legal perspective, still basically a treaty is prevail to customary rules as a lex specialis. So in that sense, even if the rules of customary international law would be changed, still the relationship between the rules of UNCLOS and the rules of the customary international law would be debatable.
And the other question I had was in terms of the international cooperation you mentioned. How would you like to see that evolving? Again, if you were in charge, if you could direct a project or put forward some ideas for international cooperation, have them acted upon, what would you be recommending? What would it look like, especially in our region?
Actually, I sometimes participate in the ongoing negotiation for establishing the new treaty on the biodiversity beyond national jurisdiction. And also, as I mentioned, in the ISA, now the new rules for the exploitation is being discussed. But as far as I know, so Japan, New Zealand, and Pacific Island states cannot make a kind of a cannot establish and say the common opinion in the international fora. So because especially in the case of the biodiversity beyond national jurisdiction in so-called BBNJ, especially in the BBNJ negotiation, the kind of distinction between the developed states and developing states, the claim of each side is kind of debated, and in that context, the position of Japan and the position of the Pacific Island states are a little bit different. But as I mentioned, in this field, still Japan as an island state and also Pacific Island as an island state can share the common interests, so probably it's better for them to appeal their own interest and to say that these kind of rules are needed for the island states. So that is a kind of international cooperation which I can expect.
Right.